Hello guys, and welcome back to another episode of my lecture. On today's episode, we'll be talking about section 6, subsection 2 and subsection 3 of the Evidence Act. In my last class, I talked about section 6, subsection 1. That's the part 1 of this particular episode. And then I told you about motive and preparation, and the fact that when you're talking about motive, you are then talking about the torchlight section. Section 6, subsection 1 is what I describe as a torchlight section. And then section 6, subsection 2 and subsection 3 are things that we're going to discuss in this particular episode. So section 6, subsection 2 tells us that the conduct, whether previous or subsequent to any proceeding of any part to any proceeding or an agent to such party in reference to such suits or proceeding or in reference to any fact in issue in it or a fact relevant to it, and of any person, an offense against whom is the subject of any proceeding, is relevant in such proceeding if such conduct influences or is influenced by any fact in issue or relevant fact. Now, also, conduct, whether previous or subsequent, to any proceeding of any party or their agent in reference to any fact in issue, and conduct of any person, an offense against whom is subject of proceeding, is relevant if such conduct influences or is influenced by any fact in issue. What are we saying here? So, for example, someone has been alleged to kill somebody, and the prosecution wants to tender that immediately after killing the person started carrying his document to fly out of the country. And then the other party objected and said, "My lord, this has nothing to do with the fact in issue." Then the person brought section 6, subsection 2 and told my lord that yes, he might think that it is not relevant because it has nothing to do with whether or not he has killed the person or whether or not he has intention of killing the person. But my lord, when we look at section 6, subsection 2b, it tells us that of any person, an offense against whom is the subject of the proceeding is relevant in such proceeding if such conduct influences or is influenced. So my lord, he did not travel before he died. That's the other party, the deceased. He didn't travel a week ago. He didn't travel a month ago. My lord, he was about to travel the moment the deceased died. Can't we see that that particular conduct of about to travel is influenced by the fact in issue here, the fact that he has died, the fact that somebody in this case has died? Do you understand what I'm saying? Any conduct subsequent to an act done. So I want you to picture two things in your head. The first thing I want you to picture is the fact that somebody has died on May 5th. Do you understand? Someone has died on May 5th. And on September 5th, there is a court case. Put those two dates in your head or write it down. May 5th, September 5th. Now, draw a line between May 5th and September 5th. Anything that a person does between May 5th and September 5th, between when the person died and when the case was brought to court, anything a person does is admissible if it is in relation to the fact in issue or if it is influenced by the fact in issue or has influenced the fact in issue. Do you understand? That means if it influences the fact in issue or is influenced by the fact in issue or is in relation to the fact in issue, it is relevant to court. That is why when lawyers talk to their clients, they tell them, sit back and do nothing. Do nothing, because anything you're about to do is going to be admissible against you, and I'm going to have a very difficult time disproving it or delinking it from the fact in issue. So please sit down and do nothing. Do you understand that? The reason lawyers have to tell their clients that is so that they don't act like fools that they are. Because, I mean, most clients are fools. I think that's one of the rules of lawyering. You have to basically babysit your client. Don't do this, don't do this, don't do this, don't do this. Do you understand that? So, when you're talking about section 6, subsection 2, it tells us anything that comes before the proceeding, but after the occurrence of the fact in issue, is relevant in court. Do note also that it is not only the person, that's the accused in this case, or the party in this case, that can take an action. If you look at A, it tells us of any party to any proceeding or an agent of such party. It tells us that when you are telling your client to sit down and do nothing, don't let your client carry the phone and send somebody to do it on his behalf. Because if someone does something on his behalf, then that is also relevant. So for example, we have the Miriam Sanders case, where Miriam Sanders was alleged to have killed her husband. Then Miriam Sanders goes to the hospital and told her housemate to go and clean the blood. Do you understand that? Now, there are two sections that are coming into play here. First of all, we are looking at section 5, the effect of killing. That's the effect of occurrence A. Miriam Sanders stabbing her husband is that there must have been blood that has been spilled on the floor, which means that blood is evidence. Do you understand? That blood, the same way we have the case of Aaron Stewart, where there were marks and the court held that the marks were admissible. That's the same way the blood in the case of Miriam Sanders is admissible. Miriam Sanders knew that that blood would be admissible. Then Miriam Sanders said, okay, so what am I going to do? Then there was a conduct that followed after it. That conduct is what is going to come under section 6, subsection 2. The conduct Miriam Sanders is going to do to either influence the fact in issue, or the conduct is influenced by the fact in issue, would then be admissible under section 6, subsection 2. But note that she didn't do it herself. She invoked section 6(2)(a), sending a party to do it, sending her house girl to do it. Do you understand that? Sending a house girl. So it then a little bit distinguishes what you will find in section 5. It tells you that when you're looking at section 5 are things that are the effect of a thing. So I shoot. The effect of me shooting is that people are going to hear loud noise. The effect of a thing is what will come under section 5. Do you understand? In section 6 of section 2, your conduct after a thing has happened, the accused is the person that is being looked at in section 6 of section 2. But in section 5, it is not the accused that is being looked at. It's the thing that the accused has done. What is the effect? When you break glass, what are you going to find in your shoe? The remnant of the glass that you have broken. When you do something in a crime scene, you are supposed to see the blood. The effect of that thing that you have done are evidence under section 5. The conduct that you take to those things are evidence under section 6 subsection 2. Section 6 subsection 1 is our torchlight provision, and our torchlight provisions only tells us that you have to admit motive or preparation. Section 6 subsection 2 tells us that anything that you do after a fact or issue has been committed, has been done, anything you do previous to the proceeding is admissible in court. Anything you do previous to the proceeding is admissible in court. That's what section 6 of section 2 tells us. So section 6 of section 2 is your conduct, not the effect of that thing. Do you understand? I don't want you to mix it up together. So I need you to understand this very well. There are like 3 elements to this provision. The first one is that you must have done a particular thing. You must have done a conduct, an act. And that act could have been done by your agent. That act is subsequent to the proceeding, but it was done after the fact in issue. And that act must have influenced the fact in issue, or must have been influenced by the fact in issue. And I gave you the example of Miriam Sanders. When she killed her husband, there were blood on the floor. That was the effect of killing her husband, and that's admissible under section 5. But the act which is admissible under section 6 of section 2 is her telling her agent, the house girl, to go and clean the blood. That is admissible under section 6 of section 2 as relevant evidence. Although it has nothing to do with her killing her husband, but it is relevant by section 6 of section 2. And with that, we move then to section 6 of section 3. The word conduct in this section does not include statements unless those statements accompany and explain acts other than statements. But this provision does not affect the relevance of statements under other sections. Now, when you are looking at section 6, subsection 2, it doesn't include statement. That's our rule. Except the statement is about to explain an act. So, for example, when the house girl wants to go to clean the blood, is it sign language that Miriam Sanders used to tell her? No, now. It is not statement. Those statements that Miriam Sanders has said will come under section 6, subsection 3. Do you understand? It comes under section 6, subsection 3 because under section 6, subsection 2, it doesn't tell us statement, it tells us conduct. Do you understand? So if you now want to admit those statements, you admit them under section 6, subsection 3, where it says that conduct doesn't include statement except the statement tells us more about the conduct. So we go to section 6, subsection 3 and say, yes, Miriam Sanders has stated that she should go and get the blood and clean it. She even told her not to use any cloth. She told her to use this particular cloth, and immediately she's done, she should burn it and bury the ashes. Do you see what I'm saying? There is no way you will understand the fact that the house girl has gone to clean and done certain things if you do not understand what Miriam Sanders has said. So therefore, Miriam Sanders' statement is therefore explaining towards the conduct, which is what section 6 of section 3 is telling us, unless those conduct accompany and explain acts other than statements. Do you understand? Then we then go to section 6 subsection 4. When the conduct of any person is relevant, any statement made to him or in his presence and hearing which affects such conduct is relevant. You might not understand this very well until we read the case of BESSELA versus 10. Now you should have this authority in your head because this is the authority of promise to marry. You need to really have it in your head. I think I even quoted it under admissions as well. So please make sure that you have it in your head. Now, there was a breach of promise to marry the defendant. The plaintiff claimed to have had sex with the defendant based on promise to marry her, and she gave birth to an illegitimate child. The defendant's sister testified that the defendant had promised to marry the plaintiff, and even after the child was born, she overheard the plaintiff saying, "You always promise to marry me and you do not want to keep your word," to which the defendant kept silent and did not say anything. The court held that the defendant's silence was confirmation enough as conduct of one may amount to an admission. Now let's go back to section 6 subsection 4. It tells that when the conduct of any person is relevant, any statement made to him or in his presence and hearing which affects such conduct is relevant. So you see, the silence of the defendant in this case was very relevant. Any statement made to him when he was carrying out that conduct is also relevant. What was the statement made to him? The fact that the woman, that is the defendant's sister, overheard the plaintiff telling the defendant that you always promise to marry me and you do not want to keep your word, to which the defendant kept quiet and did not say anything. At that point, those statements make so much sense and are admissible in court. Under admissions, we are not looking at the statement being admissible. We are looking at the conduct being admissible under admissions. Under section 6 of section 4, we are looking at the statement being admissible because there is a conduct that is relevant. Do you understand? The conduct here is relevant. By virtue of the conduct, the statement is relevant. Under admissions, by virtue of the statement, the conduct is relevant. Do you understand that? So, with that, we then go to section 7 of the Evidence Act, and we seem to be progressing, which is a very good thing. We go to section 7 where we talk about facts which are necessary to explain or introduce relevant facts. And with that, I'll see you in my next class.